Whenever we are organizing any program, academic program, we should have some members of team, those who are new design. So I'm representing here as the reserve players. I got message yesterday from Dr. Chanchandwar, that you have to take session 2. And it's an opportunity for me to have interaction with you. Today, what I'm proposing is that let us have an interactive session rather than going on for the teaching. Okay. And then I asked the captain, what is the problem? He told me that is topic to be set up. And it is very, very to decide topic initially. Initially, I was planning to take a session on research methodology. Then I thought yesterday you had one session from Professor Patiala. Anand. So I thought that let us move forward. You have already some sections on access to justice and also in the ancient and medieval periods. And what I'm proposing is that let us have interaction on the social transformation to Constitution of India. It is a huge topic. How the Constitution has transformed whole concept of justice and what was there in the mind of the framers of the Constitution when Constitution was being drafted. How they will proceed forward. Before coming to the topic, I have one question from all the participants. When we talk about the codifications of the, we start directly from the Magna Carta, and then we come to the first written constitution. Was there any written document in form of codification of law prior to that? That also.
Government of India, 1930.
We are talking ancient.
Fourth Magna Carta. Sir, Hindu
Indian- Yes. Navitya, you got right. I'm happy that.
He was my teacher.
Yeah, I'm happy that Navitya is here. She was not, I cannot say teacher, but we used to have interaction in Indian Institute, and I take session there for human rights. And I used to tell all of them that anytime you bring my colleague, and Navitya approved that. She is my colleague right from the when this institution was established in 2016. Thereafter. Thank you, Navitya, for giving me this honor that you are my colleague here.
I can never be your colleague. I'll always be your student.
No.
Every time I interact with you, there's a process of learning that happens.
Yeah, that's the No. Any idea about the Hammurabi Code? What was it?
The penal code based upon the principle of justice.
So then what will say? What is the starting point of the codification?
Bologna and
Even China can code.
Mano code.
Then why you are coming rightly? Generally, we start from the Magna Carta. Why we are forgetting? Because your topic is the ancient and medieval period. So we should start from that era itself. Okay. Now, so far in India is concerned, India, we have the transformation of society right from the beginning. Initially, we were having the Smriti, Shruti, Dharmashastra, and so it was not codified. Okay. Now here I like to bring two words. One is social change, another is social transformation. Is there any difference between social change and social transformation? And what is its relevancy when we talk about the law and justice in social transformation? Is there any difference between these two? Social change and social transformation.
The change is incremental. this big way of change?
I think transformation is a gradual process, happens systematically. Change can be immediate, irrespective of consequence. Anybody can.
एक दो वर्ड होते हैं, एक तो कहते हैं जो ग्रेजुअल प्रोसेस होता है चेंज का, एक बार होता है जैसे टायर कलर होगी एकदम से ट्रांसफॉर्मेशन हम उस कॉन्टेक्स्ट में लेंगे। सोशल चेंज की जहां तक बात होती है, there is one quotation by one of the authors that social change in its most concrete sense means social change that when a large number of people are engaged in a group activities and relationships that are different from those in which they or their parents engaged in previously. Parents were following some certain law, and now this change is coming because of the time-based requirement in the society itself. There are many mechanisms for the social change. We can say that the technology is there. Latest, we can take example of that. Ideology is there. Competition is there. Conflict is there. And political and economic factors are there. They are responsible for the social change. One question that comes time and again is that whether the law is instrument of social change. Law is changed by the society or society change.
Both.
Very recent example of network case when the government was forced to change the CRPC was changed, and it was by way of force from the society, compulsion. The change required in the society can be initiated by the single person. And this has been proved in India time and again. That's the example of Raja Ram movement. What initiative were taken by him? And then there is another example of Mahatma Phule. What was it?
Education of young
Got education. Before that was not allowed. This change was started by single person. And then Anna Hazare started from that individual. Now, later this reached Anna Hazare movement. No. We got one chief minister also out of that. And then government in Delhi and now another government in Punjab. If you go by the Indian tradition and culture, we are having the Indian culture division of the four rivers. Can you guys?
Dwapar, Treta, and Kaliyug.
And which one is the best?
Satya.
Times. That was considered to be honest, truthful, and people were considered to be perfectly happy to do that. And what is the difference now? Kaliyuga is there. How this Kaliyuga is there? It is called as the worst period. Here, man is known to be false, dishonest, selfish, and so many allegations are there. And it is also there that when this Kaliyuga will come to end, then again Satyuga will come. That is what is told in this mythology. Now, I'll give you some definition of social changes, social transformation, because we are gradually changing the society and its elements. So far as social change definition is given, there is one author is there, H.P. Mazumdar. He has given a very good definition of social change. According to him, Social change may be defined as a new fashion or mode, either modifying or replacing the old in the life of a people or in the operation of the society. Very good definition. Another definition is given by another jurist, that is Mercular and Page. Social change refers to a process responsive to many types of changes. Changes in the man-made conditions of life, to changes in the attitude and beliefs of man, and to change that go beyond the human control to a biological and physical nature of things. That is change gradually that is taking place. If you go by the definition of social transformation, social transformation refers to a systematic, universal, total, and a revolutionary overhaul of a global, including the transformation of cities, societies, culture, marketplace, and more. It can be defined as a transformation of consciousness. A new civil, conscious evolution, and paradigm change. That is brief definitions of social change, social transformation. Now come to the constitution. When the constitution was being drafted, what was there in the mind of the framers of the constitution? So many social evils were there, right from bonded labor, caste system was there, and so many other problems were there. I'll give you the three prominent social informants or the framers of the constitution. First is Mohandas Karamchand Gandhi, though he was not a part of the constitution making process. Long before, when after 35 we were seeing that independence will be there, he has given a very good his observation about how the future constitution should be. I'm quoting what he says. His vision was about the Swaraj. I'm quoting what he told. Swaraj will not be a free gift of the British Parliament, but it will be merely a continuous reflection of the declared wishes of the people of India. The ratification will be treaty to which Britain will be a party. British Parliament, when the settlement comes, will ratify the wishes of the people of India and express through the freely chosen representatives. That was vision he has seen how the independent India should be. And then Nehru. At the time of when the constitution was being drafted, his vision was that, I'm quoting, the first task of this assembly, that is about the Constituent Assembly, is to free India through a new constitution, to feed the starving people, and to clothe and make masses, and to give every Indian fullest opportunity to develop himself according to his capacity. One word that is very important, develop according to his capacity. That cannot be removed. Whatever capacity the individual is having, it is according to their. Nehru had a vision of social change through the constitution. But the opinion of B.R. Ambedkar as expressed in his speech just day before the Constitution of India was made. before the India was being adopted, very important as it was just like a warning serving to the future governments. In his last visionary speech after the submission of the draft Constitution on November 25th, 1949, Ambedkar warned of three possible dangers to the newborn democracy. These three related to social and economic priorities, use of unconstitutional methods, and zero worship. So very, very important, remarkable feature of his vision was about the inequality in the society. And constitution was there, draft constitution was there. It was given to the people of India for their opinion. On the basis of that, we are having the provision for affirmative action in the Indian. What is the affirmative actions? Reservation. Reservation policy in India is the same what is called in United States of America, affirmative actions. That is about the vision that he has seen. Now, if we ask one question from any student, why we are focusing on this Indian Constitution as adoption 25th of November. What is its importance? Is there any relevance of 25th of November in regard to the Indian Constitution?
So they handed over the final.
Karachi, yes, it was handed over. And ultimately, it was decided that we have to observe 26th of January every year as a Republic Day. What is this Republic Day? Any answer for that?
Constitution was in force.
The transformation from subject to citizenship, monarchy to.
This Republic Day used to overshadow the term of the Constitution. Constitution was adopted by the we the people. Okay. So perhaps that was the sincerely felt by some for which 26th number is being observed at the Constitution year. ये इनिशिएटिव तो प्रेजेंट गवर्नमेंट ने दिया, उससे पहले ये किस नाम से जाना जाता था? लॉ मेकिंग. मेरा एक सौभाग्य है इंडियन लॉ में था जस्टिस राजेंद्र बाबू और नो NHRC के चेयरपर्सन बाद में बने थे. He was having 5 years of history. Me and Professor Shivapal were asked to write this speech to Kejriwal question on 26th of June. So we thought it would be a draft. We wrote that draft and we were surprised it was read as it was presented before. That was not done. So that is a relevancy of this 26th of Law Day that is being celebrated every 26th November as a Constitution Day now is being observed every day. Now I'd like to take you to another scenario that is with regard to the Constitution as an instrument of social change. Is it or whether it how the Constitution has worked as an instrument of social change? My first point will be Constitution. It should be understood as it was adopted on 26th of November 1949, along with the successive amendments that was made by way of provision of Article 368, Clause 1 of the Constitution. What does Article 368, Clause 1 says? Nothing, notwithstanding anything in this Constitution, Parliament may in exercise of its constitutional power, amend by way of addition, deletion, or repeal any provisions of this constitution in accordance with the procedure laid out in this article. So far as constitution has been amended more than 100 times, according to the demands and circumstances. Many times, constitution provisions are also being supplemented and complemented by the acts passed by the parliament and state legislatures and judicial interpretations. It is open for judicial interpretation. Any amendment or any legislation made by way of that amendments. There can also be included in the term constitution to have proper grasp of the constitution of. So, first property that we have to read the constitution as it was adopted at the time of the adoption on 26 November 1949 and subsequent amendments. Second, we have to look into the broader set of the political values, ideals, and goals. This is why constitution cannot be neutral. There are always more or less many complicity with ideological priorities. The framers of the constitution therefore seek to invest their regime with a set of unified values, sense of ideological purposes, and that can be used in context of the policies. In many cases, there are the accomplishment of that the goal of the preamble, the constitutional document, which often set for the nation. In this sense, preamble in the Indian Constitution represent the nature of the state and the objective value of the Constitution that is enshrined in the preamble. Sovereign, socialist, secular, democratic republic, that is the nature of the state, where the word justice, liberty, thought, expression, belief, faith, that is incorporated in the preamble of the Constitution. Third meaning is that has been defined or quoted by C. N. Sarkar in his book, that is about the social change referred to the process responsive to many types of changes. That changes in mandate of the conditions of life, changes in attitude and belief of man, and to the changes that go beyond the human control. There are changes relating to variations in modifications of many aspects of social process, social pattern, social interactions, and social organizations. That is according to the time and space, whatever changes is required, that is being incorporated in the Constitution. Now, I'd like to move all of you to the next stage, that is about the Constitution of India that has mandated and have been brought about by the government through public policies. Here, I'd like to bring 4 to 5 points, very relevant and important, that first, the nature of the state as discussed, either giving the definite changes that have taken place in the society, or India is now sovereign state, where constitution coming into effect with the domain of state, coming to the end of India become like the sovereign state. It was not dominated by anyone. It is now a sovereign state. There are many socialist measures that has been taken or drafted in the constitution. That is with regard to the provision to eradicate the poverty, ignorance, disease, inequality between men and women, especially in wages, insecurity of old, disabled, orphan, invalid the widow, exploitation of workers, classes, etc. There is provision for abolition of Jimodari system. Constitution was amended for that. And Tennessee reform, ceiling of land holding, consolidation of cooperative farmers. They are the other methods that India has taken the adoption of the constitution that can be said at the transformation after the incorporation of the Indian Constitution. Indian Constitution, there is a provision for adult suffrage that has introduced that every citizen of 8 or more without any reservation of sound mind, they are eligible for the death thereafter. That is India. And above that, 73rd and 74th Constitution Amendment is there, wherein Panchayati Raj system and municipalities division is there. And above that, provision for reservation for given 33%. Now, some of state they have reserved seat for the up to 50%. And this is a transformation and change that has brought like that. Second, objective and values such as liberty, justice, equality have wider social implications. The Constitution has guaranteed to the Indians a set of fundamental rights. Not only given in the Constitution, there is provision for enforcement also. The better experience of the people during the British rule. Right to freedom of speech, expression was there, not there. So many hurdles were there. Right to equality, equality before the law concept was not there. So it was somewhere in the mind of the framers of the Constitution that all these provisions were taken care and they were incorporated in the part of the Constitution. And then untouchability was there. So that provision was also taken care of. And after independence, this untouchability offense it was made and special provisions were made. Constitution Article 25 clause 2 is specifically taken there. Provision for reservation, employment. That care has been taken in the Constitution by way of transformation. In addition to that, there are certain welfare measures, such as minimum wages at 1948. It is by way of the Constitution. Provision is there, then special legislation has been made in this regard. Contract Labor Regulation Act, Child Labor Provision and Regulation Act, Bonded Labor System Abolition Act, State Union Act, Mines Act, Factories Act. These are some of the examples. It is the best example of social transformation. Now, third phase, very relevant, important, is the right education. Free and compulsory education. Initially, it was not fundamental right. Constitution was amended. Specifically, Article 21 clause 3 has been incorporated. And there is another good initiative that is about the right to work through Manrega. Earlier it was Manrega, now it is wherein there is certain minimum days fixed for the workers on the grassroots level, which has in order to give the opportunity for livelihood. Then, Right to Information Act, Lokpal Act, Lokayukta. These are some of the best examples of the social transformation. Moving further, several amendments made in the Constitution. That has also made revolution in the society. Here I like to quote Justice Sikri, former Judge Supreme Court. He has given certain observation that number of observation amendments in the Constitution. He has quoted amendment, First Amendment, Fourth Amendment, 17th Amendment, 24th Amendment, 25th, 26th, 29th, 34th, 42nd, and 64th, etc. They have been carried out in the context of changing socio-economic changes in the society. The Union government was determined to see that the right to poverty reflected by the Constitution did not come in the way of the development of the country toward the egalitarian society. First Amendment, as well as the Fourth Amendment of the Constitution, they were inspired primarily by the objective in this view. Aggregating reforms were made thereafter. The first one in the year 1951 replaced the Jamandari abolition laws beyond chance before the court of law and inserted Article 31 clause A for the purpose. It also amended Article 15 in the interest of educationally and economically backward classes. In similar ways, the other amendments have been brought to bring social revolution in the. Now, the revolution or the change made by the Supreme Court, that is fourth point, also that is the Constitution. That is with regard to the public delivery system by way of public interest litigation, also social interest litigation. What is the purpose? Purpose is that it is cheap, quick, and not so formally system. And here, Supreme Court has sometimes also brought the concept of so much. Many cases they are being taken by the Supreme Court on by way of its own sources also. This is the so these are my 5 points. Basically, how the Constitution has made change, how the Constitution is instrument of social change. Now, if we see the Constitution as a working, we can see there is a rise of the people. A rise of people is starting point itself when the Constitution was, when the Constitution is being adopted by the people of India. So, ultimately, it is the beneficiary of the people. Just see the, before we got the adult franchise, the British has introduced an elected system of legislature for India. Before coming into the force, there was provision that only 50% of Indian people, they were able to cast them. The criteria, what was the criteria during their period? Education. Only 50% Indians. Immediately when the Constitution was adopted, first target was to try to. So it was a mandate later on. Now it is the age of 18. Earlier it was, yeah. So this is one of the response to social transformation, where voters, they have voting right without having any conditions of their property and education. And Constitution has made the people of India as the ultimate master of their destiny. And it has also made the every Indian without any distinctions. Now, if you see the rights of the people, there are two types of rights given in the Indian Constitution. First is granted to all people, and other rights are granted to citizens only. This provision is incorporated under under part 3rd of the Indian Constitution, that is also known as the fundamental. Can you see what is the similarities between the Universal Declaration of Human Rights and part 3rd of the Indian Constitution? No, that will not say. You have not to participate in this process. Universal Declaration of Human Rights, Universal Declaration of Human Rights, and part 3rd of the Indian Constitution. What is the similarity?
What kinds of civil, political, economic, here, part 3 confining ourselves to mostly civil political rights, and social cultural rights are put in part 4.
My specific question about the Universal Declaration of Human Rights and its similarity with regard to the part 3rd of the Constitution.
So right to life, right to equality. All these rights are same.
How many articles are there in the Universal Declaration of Human Rights?
30.
All are the part of part 3rd of the Indian Constitution. And Mr. Clausen discuss kiya tha. And just see the timing. Universal Declaration of Human Rights was adopted on 10th of December 1998. And when the Indian Constitution was adopted?
2050.
It was the time when at the one hand the Universal Declaration of Human Rights was adopted and Indian Constitution was built. Similar. Almost all the provisions of the Universal Declaration of Human Rights are in part 3rd of the Constitution. Yes.
I think so it was corresponding to the part of fundamental rights. It's a part of
Universal.
universal declaration, but it's not there in the fundamental.
It is not there specifically.
Because
If you go by the interpretation by Article 21 of the Indian Constitution, though the judiciary has expanded the scope,
yes, I understand that.
specifically it is not mentioned there.
So because specifically that right is a part of the draft one.
It was draft of the Constitution. There was so many debates at the time of the heading of the Constitution. It was dropped out at the last. It was, but never. It is part of fundamental right by way of interpretation of Article 21 by the Supreme Court. Not only so many rights, spirit rights, right of the prisoners, and not only that, the right to sleep also as a fundamental right, which is not in the. We'll have the brief analysis of right of the people. One is that is by way of available to the person and another available to the citizen. First kind of right, available to non-citizens, including what are the right? Equality before the law and equal protection of law. Article. Then protection against unlawful conviction. Article
22.
Article 20. Life and personal liberty.
21.
One of the smallest articles of the Constitution for which widest interpretation has been given by the Supreme Court. Right from A.J. Gopalin to C. Chan's narrow interpretation and widest possible interpretation. Procedure should be there. How the procedure it should be reasonable, just, fair, and reasonable. And now all these words, just, fair, reasonable, have gone by this interpretation by the Indian judiciary. Now, protection against unlawful detention.
So Article 22.
22. Right against exploitation in the form of trafficking human beings. 32. 23.
22.
Article 24. Child.
Child.
Then right to freedom.
19.
25. Freedom of religion. 25, 26, 27, right, all these. These are available to non-citizens. Now coming to the other rights. Right against discrimination by way of status. Article 15 is there, 16, 17, 18. All these up to 19 articles. They are available to the citizens. As I mentioned, there is a special provision for the employment, Article 16 and 15. mandate after landmark judgment of Mandal Commission case that is also known as the investment case. And one concept was brought there, criminal section. And criminal section is not applicable to the middle class ratio, right? This provision is available only for OBCs. Now, talk is going on whether it should be applicable for middle class or whatever. I have done my research PhD on reservation policy for scheduled caste and scheduled tribe. Social legal study with reference to the human rights. It was the time when the report of Mandal Commission was accepted by the community. Lot of huge inquiries against that. And it was a time when I discussed my supervisor that it is a fit for research. Before that, I was also not in favor of having reservation. After more than 50 years, there was a cap that reservation should be up to the 10 years. It is being extended every time. And my hypothesis was that whether reservation policy should continue. And data when I collected from the field, to my surprise, that reservation policy is required. Still, it is needed. Reason is that its benefit is not reaching to the people who require that. There is also a criminal section in scheduled caste and scheduled tribe. Those who are taking the benefit of that. It is the right time. And this criminal concept should be there in scheduled caste and scheduled tribe. Only then benefit of reservation can go to the people who really require. That was my hypothesis. It was proved also. And I'm still in favor of having reservation for student assisted tribe in employment. And I collected the data, their representation in class 1 and class 2. That is below the prescribed limit, it should be there. On the basis of it. How long it should be there, it is another topic for deliberation. Today, we have the President of India, a lady who is from the tribal community. Ambedkar once said, reservation should be stopped. Then she made tribal community to reach with the President of. Now, this is a topic when the debate will start now. This academic field. Big question mark. Who can be the President of India? We are academicians and every right to discuss all these issues. Okay, this is whether it is impeachment of tribal people, or is there any other hidden agenda? It is a time for, especially people those who are in research. What should be the criteria? Who can take it? Big question. And it is a topic for academics. We can go on to the topics. So this is the part third. Now, if you see the transformation by the directive principle of state policy, part 4 of the Constitution. So these are not very important. But reality is that they are supplementary and complementary with each other. Judiciary has time and attendance. We cannot live in isolation. These are fundamental for the governance of the country. Every time when the government of the day, they'll go for the people, they have their manifesto. Manifesto is based on the part 4 of the Constitution. That is what they will do for the people once they got in the power. So I'll start with the Article 38. So many articles. The state shall in particular strive to minimize inequalities in income, eliminate inequalities, status, facilities, blah, blah, blah. These are the goals set for the government. Article 39. I'm giving the book, you can have your own note on that. Article 39A, that was incorporated by after the 42nd Amendment of the Constitution. Then another talk that is very widely going with the academia about the Uniform Civil Code. Is it a time, right time, when we can go for the Uniform Civil Code? If yes, what about the personal laws? Whether it is applicable, it can be applicable in a country like India, that is another big target. Okay. So these are the part of the Constitution. Now, role of law in social transformation in India and right of work. Role of law in social transformation in India and right of workers. Article 43 is there. Article that and then Article 43A is also there, where children weaker section, that is for their welfare and promotion. Article 45, that is amended for the right to education to the children. Article 46, social injustice, etc., etc. That speaks about that. And then Article 48, 49, these are very relevant and important. So far as Article 43, this part 4 of Indian Constitution is concerned. If we go by the change made by the judiciary as well as by the Constitution, I'll give you 2 to 3 very relevant and important examples that we have seen and that has changed the whole scenario of the social rights of the Indian by Supreme Court as well as the by Indian legislatures. In this regard, first of my example would be about the Antyodaya scheme that was launched by the government on the initiative of the. In the same line, there is scheme for midday meal. And supplementing that, there is a food that should be distributed in the school, cooked food. These are some of the examples that very important case in this regard is Unikrishnan, very important judgment in this regard, wherein the Professor Upendra Bakshi has quoted one quotation is that the last resort of the oppressed and bewildered in this country is that they should be protected by the government of the day or their welfare, otherwise it will be very difficult to work. So I was talking about the right to food, that change has been made on the initiative of the Supreme Court, and that has changed the whole scenario. What happened in 2001? There was drought in the country, and most affected states were Rajasthan, Madhya Pradesh, and some part of Orissa. And irony is that there was sufficient food in the country, but people were dying because of starvation. So people Union for Civil Liberties, they moved a petition before the Supreme Court that the situation is that in the country there is no place for reservation or preservation of food, and other place people are starving. So 3 issues were there for consideration before the Supreme Court. First was that does the right to life mean that the people who are starving and who are too poor to buy food grain should be denied food grains free of cost by the state from the surplus stock of the state responsibility, as it is lying unused and it is damaged, it is being damaged in the society. No shortage of food, but it was not taken to the food. Second issue was that does not the right to life under Article 21 of the Constitution of India include right to food? So now it is fundamental right to food by law. judicial interpretation. Third issue was that does not the right to food, which has not been upheld by the tax code, imply that the state has a duty to provide food, especially in situations of drought to people who are not in position to purchase food. These three issues were there. And by way of that, one good initiative was that public distribution system came into in our country. Now it is applicable in whole of the country. Though some categories there below poverty line and above poverty line. In the state of Himachal Pradesh, now there are that those who are giving the income tax. Their limit is there. Now, what should be their status? Whether they should get this food from the public distribution system or not. So, public distribution, people unique or civil liberties, case landmark judgment, social transformation. That until the scheme come out of this. Not only that, old age pension scheme, integrated child development scheme, national midday program, and Annapurna scheme. That were some of the provisions that came up by way of these people living for civil liberties. 2002. Then, supplementing to that, in school, how to raise the presence of the students in the schools. This provision was that the government will have the provision for the distribution of food for the students. But the problem was they were not able to reach to this. So it was on the directive of the Supreme Court that there should be provision for cooked food in the school. I don't know what the situation in the country, part of the state, but in Himachal Pradesh, cooked food is being distributed in the school up to middle standard. And in this regard, Rajasthan is the first state that started midday meal school in the schools. That is one good example of social transformation so far as the right to food is concerned. Another example is the right to education. We are having the example of so many cases are there. One is the case of Mohini Jain. It was followed by the immigration. Yeah, and now latest is the TMFI. In immigration case, Supreme Court took the scope of Universal Declaration of Human Rights and Article 13 of the ICESC. What is that? International Convention on Economic, Social, and Human Rights. That was the strength from where the Supreme Court in Unikrishna takes the stand and first time articulated education as a social right. In what education as a social right. By holding that right to free primary education up to the age of 14 years, the court was thus reminding the state of endeavor that it had to take under Article 45 within the prescribed time limit, which has expired long ago. This has been one of the first judgments where the courts have employed the ICCPR and ICESCR language for the progressive realization of the right to education, while declaring it as a fundamental right to education. Relying heavily on Keshanandi Bharti case, Justice Jeevan Reddy. In this case, I'm talking about the unification case. Use the earlier approach for enforcement of direct principles in unification case and debate moved from the justification of the right to information of fundamental. So, law and social transformation in India dealt that Justice Jeevan Reddy, he states quite naturally that it is only Article 41 which speaks of the economic capacity of the state, whereas Article 45, that's state about Article 41 states about the capacity of the state, and 45 does not speak of the limits of the economic capacity, as does the Article 41. Therefore, this hurdle does not stand as an obstacle in the carving of a fundamental right to primary education from Article 21. Now, this is now history by way of this Article 21 is the fundamental right of Constitution. Another landmark transformation by the judicial interpretation and the legislative. Third clear example is about the right to health. Not specifically mentioned as a fundamental right, but by way of judicial interpretation, it is now fundamental right. There is a very landmark judgment, that is Consumer Education and Research Center versus Union of India. Therein, for the first time, explicitly had Supreme Court that right to health is an integral basic means of right to life and personal liberty. Now, right to health and fundamental care is a fundamental right by this judicial interpretation. And there is another case, Paschim Banga, very famous case of the state of West Bengal that is very relevant so far as the right to health as a fundamental right is concerned. These are some of the judicial interpretation and its implications. Very briefly, about the Constitution and its impact so far as the social transformation is concerned. That is with regard to the codifications of Hindu laws. When this law codifications were made, 15 August 19. Hindu laws codification was one of the steps that was taken by the government of India during the mid-50s. So as to carry forward the notion of women's equality and legitimating in the Indian societies. Hindu law reforms see as the first step towards social transformation and social change, commonly referred to as the Hindu codes. Modified laws include Hindu Marriage Act, 1955, Hindu Minorities and Guardianship Act of 1956, Hindu Succession Act 1956, and Hindu Adoption and Maintenance Act 1956. And Hindu Marriage Act 1955, it has brought major changes such as removing the necessity of having the both parties from the same caste, both husband and wife, which are previously as pre-conditioned. And then affirmative actions, reservation provisions. That is again a very important change that was brought. And I have mentioned about the Panchayat Raj institutions, about there is an amendment. Before 73rd and 74th amendment, another amendment was brought by way of 64th and 65th amendment by the Rajiv Gandhi government at that time. Any idea about that? 64th and 65th. पंचायत राज में पढ़ाया गया 73rd and 74th को एक बार अटेम्प्ट किया गया था राजीव गांधी गवर्नमेंट के द्वारा पहले, बिकॉज उस पार्लियामेंट सेशन वो लैप्स हो गया था, इसलिए ये बाद में लेजिस्लेशन लाया गया था. ठीक है, तो बात हुई 73rd and 74th अमेंडमेंट होना, जिसमें विमेन के पास सब राइट है, कॉन्स्टिट्यूशन राइट है, reservation and provision for their elections in the municipalities up to municipalities and Panchayati Raj systems also. Finally, I like to touch upon the PIL concept also, very important change that has brought, but often that was misused. Still it is being misused. But the judiciary, in many cases, exemplary fines have been imposed. In such cases where that is not. And my last point would be about the Kham Panchayat. Social changes, social transformation, when we talk about. And in this regard, I'd like to have the opinion of all the parties and their opinion about the Kham Panchayat, its relevance in present day. Especially Western UP and Haryana. In Tamil Nadu or your Hyderabad, this system is not there. But here,
We unfortunately have a spate of cases wherein people who have been marrying people from other castes have been killed in broad daylight in cities of Telangana. The last couple of years, we've seen a spate of
that is known as the conflict.
yes. So we do see
Yes, please. Opinion of the participant about the Kham Panchayat.
Unfortunately, Panchayat they are very difficult.
It was there.
Yes,
It was there. No,
it is there, sir. They are dealing on static. And they employ resolve selectively all this. There were certain that were criteria which we have to. But yeah, here it is simply I thought much greater than our. In every village there is a Khap Panchayat.
but it is not codified. It is based on the custom traditions. It is not nowhere in written.
No, it is not written form, but they decide the cases upon the reason. They give up the fact, cases, circumstances, even they call witnesses. So many marriage disputes, matrimonial disputes have been very amicable. I was part of one of the Khap Panchayat, where the both parties were not agreed to live together. And the groom sides were saying that I do not have trust. I have trust in my wife, but I do not have trust in my wife's family. So our panchayat given assurance, and now it was back in I think 14 years. So I thought it is a very accessible, it is a very speedy, and it is not costly at all. People know what you need. In judicial system, we go there and they talk all about fancy terms and all these things, but they do not give justice. They are giving the
But still, it is acceptable.
yes, it is acceptable and both parties are happy.
Sir, Upendra Bakshe in Takrar to Karar talks about Rangpur Panchayat. In that particular Panchayat, efficiently, most of the panchayats are able to solve the disputes. Almost 300, 400 villages are democratically dealt by those panchayats. So that is a classical example of efficiency of panchayat. On the other hand, he also mentioned in another book, People's Law, that there are certain panchayat whereas caste predominance is there in deciding the case. So both aspects are there.
Yes, anyone about the Kham Panchayat? Now,
Besides, actually reflect the idea of how we take into we consider in total the institution as shallow and we brush it aside, then the good things of it will also be set aside.
there is a one that is known as Panchayat extension to scheduled area. Yes. Sir. Any idea about it?
Yes. Schedule 5 and Schedule 6 of the Constitution of India.
Very small act, but large implications to present the traditional customs of the tribe. Now, when we talk about social changes, social transformation, what we can see that in our country, Sati Pratha is not at all. Very few years back, this roadblock is, that was reported from the Rajasthan. Last reported case is there. Thereafter, we have not seen that. And widow marriage is accepted in our society. Initially, it was not there. Social change, social transmission. But I have serious concern about the child marriage. Those so many laws are there. In the Rajasthan, Akshay Tritiya. That is a huge function is there. Not only that, but ministers on the ground, they are the participants there. That is a big concern, a big issue.
Ask me, this is one form of validation of being given to child marriages in Rajasthan.
That is serious concern of that.
But on the other hand, we have states like Odisha that has taken a calendar by 2030. That also a bill has been introduced in the state of.
So that is good initiative. But so far as social change, social transformation is concerned, yeah.
Sir, I did empirical research in the village of Bihar regarding Musar communities. So that Musar communities, mostly people are illiterate and they are unaware about their rights, particularly constitution, etc. So the minimum threshold to avail the benefit of reservation could not reach to those people because they are so illiterate from generation to generation. So social transformation through law has certain limitations unless and until economic and literacy aspects are there in the community.
That is true. That is serious, my serious concern is that. How many of you are aware about the Malana civilization in Himachal?
That was a part of the course.
Still, it is accepted. I think that 10 years back, they were not accepting any aid, advice, benefit from the government. No school was there. No primary health centers were there. And what is their judicial system? Have you watched that in the movie?
Yes, sir.
Local deity is there.
Yes.
And the beauty is that there are 3-tier system also. 3-tier system also. So people go. Jamalu, that is at the highest level, and that decision is final. That decision is final. And another example that I'll give you from the Shimla district or the old part of Himachal Pradesh, that is Shimla, Kullu, Sirbar. Here people are having a lot of faith on their deities. Though revenue system is there, demarcation is done by the Patoris, Kalu, etc. In some cases, demarcation is done by the local deities. That is accepted. Unbelievable, but this is true. Wherever that local deity will go, that deity will mark this place. This is the border between two brothers. That will be accepted. No appeal against that. No but and if. That is the system how this ancient is going, and still it is accepted. And when we talk about the constitution is always futurist. We talk about the future. Those who believe in the custom and tradition, they do not require the constitution. Constitution is a framework. Everything is mentioned there. And beauty of Indian constitution is that there is scope for amendment. Not so rigid, not flexible. And if you compare it to the constitution of USA, when constitution of USA was adopted, which year? 89. 79. Within 1 year, it got 7 amendments. And thereafter, how many amendments till date?
Full time.
Till date,
10.
10. And now compare it with the Indian constitution. But still, I appreciate Indian constitution. We have that scope. When the constitution was being drafted, Ambedkar said that the constitution that is being drafted today We are drafting it is a project today. Time will come when the amendment will be required, can you be required this. Okay. So with this note, I'm winding up here.
Yes. Any question?
Yes, it's open.
Much.
As we are talking about these customary laws, as you had mentioned this Sirmaur district, because I belong to Sirmaur district, and I have seen, because Deti resides at our home, so जब भी हमें हमारा कुछ function होता है तो वहाँ पे खाना वाना दिया जाता है, and the members of scheduled caste they are beyond the limit, and I have seen they are made to sit at
We are not allowed to.
they are not allowed.
Yes.
So sometime what I want to say that in constitution there is equality, and with these customary laws we can say that SC understands कि okay it's okay with this system, कि ये तो हमेशा से होता है, हमारे साथ ऐसे ही होता है, कोई बात नहीं, उनको कोई hesitation नहीं होता है. So that's why जब ये through God और through deity जो है हम decision करते हैं, it may be arbitrary. Obviously, it may be arbitrary, so we can't say that that system is good and the constitution is not like that.
Jurisprudence में एक हमने पढ़ा था, when there is conflict between the customary law and the law that is been codified, which one will prevail?
There is a question, sir. Customary, in respect of customary, was actually enforced through a person who was in the power. As ma'am said, the person who is actually standing outside the certain limit. So how can we say that he is accepting this norm and he is informed to accept this? Might be possible because of that certain pressure, he started believing that
शायद
that has to be
आप
accepted.
लोग भी एक्सेप्ट करना बहुत मुश्किल होगा ये. मैं भी लगभग उसी कस्टमर से ट्रेडिशन से आता हूँ. एक्सेप्ट वो करे ना करे, शायद उसको करना नहीं होता है, उसको मजबूरी है. इसके पीछे की अगर हम थ्योरी को देखें ना, तो हम करते हैं ना पाप और दोष. उसके पाप और दोष उनको लगते हैं, वो अगर अभी आज फील नहीं करना, उसकी जनरेशन उसको फील करना. ये एक सुपर पावर है जो हमारे कंट्रोल से बाहर है, जो उसको एक्सप्लेन नहीं कर सकती क्या होता है, कैसे होता है, पर उस रीजन में ये चीज होता है. आपने एक्सेप्ट किया होगा, देखा होगा आपने, देखा होगा ना. कहीं ना कहीं एक फियर है वो, जो ये अनसीन पावर है, अनफोर्सेबल पावर है, क्योंकि ये तो हमने नहीं बनाई. मेरे दादा ने मेरे पापा की, पापा ने मेरे कही, मेरे दादा को किसने कहा, ये आगे जनरेशन टू जनरेशन चल रहा है. ये एक्सेप्ट हम आज नहीं करते हैं. इसका हमारे जो उस एरिया है जो जहाँ पर हम रह रहे हैं, इसका कहीं ना कहीं उनके डे टू डे लाइफ में फर्क पड़ता है.
बट सर दिस वे बहुत सारी ऐसी गलत चीजें तो जो जनरेशन टू जनरेशन चली आ रही थी, तो सर उनको भी हमने चेंज किया है.
चीजें सोसाइटी एकदम से एक्सेप्ट नहीं करती, ग्रेजुअली खत्म हो जाएगी.
So like honor killing in Kha Panchayat, that's part of Kha Panchayat.
पर
सती
So you can-
प्रथा, देन इलिटरेसी.
कुछ चीजें टाइम देती है, अपना टाइम देती है, होगा तो.
that point that हम लोग कहते हैं ना कि modernity आ गई है, quality, scientific development है, सभी was like backward है, but you know you a button and hundred and thousands of people die. That is development, right? But एक सती मतलब then we consider that is backward. I'm not justifying that, but my point is that our notion of thinking about something like we are all my point is that we are all constitutional converts, right? We are so conditioned that we think that constitution as a document is infallible kind of thing. No, yes, of course, versus one of the things.
हमारे यहाँ दो तीन चीजें की जाती है ना, आचार, व्यवहार, संस्कार. ये चीजें कहाँ से, जिस जगह हम रहते हैं, जिस सोसाइटी में हम रहते हैं, संस्कार की जहां तक बात आती है ना, आजकल सारा दोष डाला जाता है स्कूल में, टीचर बच्चों को सिखाते नहीं. संस्कार तो परिवार से आता है, परिवार में देने चाहते हैं. जो हम अपने बच्चों को सिखाएंगे बच्चा वही सीखेगा। आजकल प्रॉब्लम है मेट्रो सिटीज, ये शायद हमारे बड़ा में दिक्कत नहीं है। मेट्रो सिटी प्रॉब्लम है, दोनों हस्बैंड वाइफ काम कर रहे हैं, अच्छी जॉब है, मजबूरी के काम करें, बच्चा किसके पास रह रहा है? मेड के पास। मेड के पास संस्कार क्या आएंगे? सबसे एक वो और दूसरी एक मेरे को जो लगता है, कटकर में रहता हूँ, पेरेंट्स कब पहुंचते हैं घर में? रात को 10-11 बजे या 11 बजे, तब तक बच्चा सो जाता है, फिर उसको स्कूल जाने। बच्चा और पेरेंट्स की मीटिंग कब होती है? छुट्टी वाले दिन या संडे के दिन। संस्कार का पाठ तो खत्म ही होगी ना, वो चीज तो खत्म ही होगी ना, जो चीज हमारे थी, हमारे साथ जो थी हमारे यहाँ। फिर रही आचार और व्यवहार, ये जो हमारे गुरुकुल शिक्षक पद्धति थी, वहां पर कोई डिग्री की एजुकेशन नहीं दी जाती। वहां पर ये चीज कहा जाती है, आपको हर सर्कमस्टांस, हर परिस्थिति के लिए आपको तैयार किया जाता है। आपका कंडक्ट कैसा होना चाहिए, आपका बिहेवियर कैसा होना चाहिए, आपके गुरु के साथ कैसा, अपने कुलीग के साथ कैसा, वो वहां पर वो चीजें सिखाई जाती है। शायद वक्त के साथ ये चीजें बदल दी गई है, और शायद आने वाले टाइम में स्कोप ही नहीं रहेगा।
I think, sir, every society has a value. Just always say, Constitution brought new kind of values, and every society has values. Sanskar is a kind of values which is in part of society. So there is interface between values grown through customary practices and values given through Constitution. In that interface, some of the values are modified, reshaped, or eliminated, and some of the values are displaced so that constitutional values may be implanted on that particular place. So as long as there is exposure of civilization and tribal society, that kind of interface will change not only the value of tribal society and village values, but also it will change constitutional values. So for example, 73rd Amendment is an example of modification of constitutional values, learning from the experience of indigenous values or tribal values. So we can't say there is a fixed values, always will remain, because whenever I have interaction with you, I will learn something from you and you will learn something from me. And that is how we both are going to be transformed. Yes. So any other question?
The constitution is a living document. That tradition is not an organic, like organic. That tradition is equally is an organic tradition or organic custom, right? We can modify that as well. And I'm talking of what our gaze, how we think. We promote that constitution is our organic document. Therefore, means constitution in that sense is a positive document. Custom in that sense is a negative document. And not document, negative practices.
Postulate.
Yes. That's my point.
The custom is always not needed.
No, I'm saying in our imagination.
And the constitution itself has given enough space for custom to grow hand in hand with the constitution. It is not.
As it really happened.
At the scope of the pen custom, you and I are being given the choice to have a religious freedom. See, compare our constitution with, say, the France constitution or the Italian constitution. There you cannot wear your religious symbols. Here you're not, you're allowed to wear your religious symbols to come to school, college, go to public spaces, look at the chief ministers, prime ministers, all public offices. You are allowed to profess your custom tradition, even holding a public office. So yes, a constitution do provide a space to continue with constitutional values hand in hand with customs. Yes, those customs which probably are not in consonance with the constitution anymore as being given time. Otherwise, yes, I think.
Savini, German philosopher, said that law in customary form evolves just like language or the branch of trees. So it is not perceptible, but it is happening. Change is happening. So such said, social change and social transformation. Social change comes through customary practices. It is already happening. Social transformation, classic example, Indian Constitution. What Granville Austin said, it is social transformation.
The idea of constitution is not fallible. What is written in the constitution can be fallible. So what you say is, we all have that gaze that constitution is infallible. If the idea of constitution is infallible, what is written in the constitution we have to evolve. Otherwise, constitution also will become fallible.
That's why there is a,
Main point is regarding the codification of the tradition. If we codify a particular tradition, it stops going. That's what we want.
There's no scope. Once it's codified.
Once you have 45 days.
But his idea
That's why we
was
have our.
we all have that, we have all of this as a prejudice.
But even after codification, there is interpretation. And interpretation brings subtle change. Just like SCST.
And we have to codify it again.
Yes.
Exactly.
So everything is changing, even interpretation, it's changing the things. Because codification is what? Assemblage of sign, symbol, and you have to interpret it.
And in the last session, census subject, why property has not been defined.
So with this note, thank you so much, sir, for giving us insight regarding social change and constitution. Thank you for this lecture.
Thank you.